confirmation hearing for Trump's attorney general pick spells bad news for gun rights advocates. Plus, the Supreme Court kicks the can on a closely watched assault weapon ban case. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today and sign up for our free weekly newsletter and keep you up to date on all things happening in the world of gun politics and policy. To kick us off this week, the big story we want to talk about is the first set of confirmation hearings for the incoming Trump administration, and in particular, the hearing related to his preferred attorney general pick, former Florida Attorney General Pam Bondi, and maybe the lack of attention paid to a subject that, by all accounts, probably should have come up and certainly had some outside interest in coming up, and that's guns.
And it did come up, right? Just not maybe in the way that gun rights advocates had hoped for or wanted to see, because the person who asked her about her record on gun policy was California Senator Padilla. So the Democrat from California asked her, and really asked her in a please endorse these policies that you've previously supported, sort of way. And her response is, I doubt a lot of gun rights activists are going to be happy with them. She said, she did say, I am an advocate for the Second Amendment. And then she added, but I will enforce the law of the land, which, not necessarily a hugely controversial statement on its own, but generally speaking, gun rights activists tend to turn a skeptical eye at somebody who starts out a sentence with, I am an advocate for the Second Amendment, but that's a pretty common formulation in politics and one that often leads to ire from gun rights advocates. So, she didn't say, to be fair, she didn't say a whole lot. The other half of her answer on gun policy is also not necessarily super reassuring, I think, to gun rights activists, in that she went on to explain that her gun views were formed in the wake of a number of mass shootings that she responded to as Attorney General, including Parkland and the Pulse nightclub. And she was also involved in the response to the Las Vegas mass shooting. So, her argument was essentially she supports the Second Amendment, but also would enforce whatever laws are on the books or put on the books. And her view of gun regulation is formed primarily around her experience responding to mass shootings, which is kind of what you often hear from Democrats, frankly, on the way that the parties have gone the last 15, 20 years. You'd more expect to hear that sort of reasoning from them. She did not, however, commit to backing any sort of national gun control proposal as Padilla had asked her to do. She did say she would look at any proposals he has and go from there. So she didn't rule it out, but she also did not actively endorse any sort of proposal at the national level. She's previously supported, and was involved with drafting Florida's essentially their red flag law that they passed in the wake of Parkland. Also the age restrictions that they put on buying guns for 18 to 20-year-olds in Florida after Parkland. She backed that and fought to defend it in court as Attorney General, which, there's a certain obligation that the Attorney General has to defending the laws of her state or the nation if she's confirmed as Attorney General. But that is something that's garnered a lot of criticism among gun rights advocates during, her tenure as Florida Attorney General. And what she said is probably not very reassuring for gun rights activists. And then I think the context of it is even less so, right? Because again, it was not a Republican senator who pressed her on these issues. There was no Republicans or gun rights advocates in that hearing tried to get her to renege on her previous support for these gun restrictions or promise not to use the department to defend or expand gun restrictions in the United States. So that's a bad sign for the overall power of the gun rights movement as it stands today. You know, certainly I think most gun rights groups they recognize that they're in better spot than they would have been under a Harris administration, perhaps, and whoever would have been nominated attorney general there. And then they'd be willing to make the trade-offs involved with second Trump administration, and that he has himself a fairly mixed record on guns. He's got a number of accomplishments, mainly involving the appointment of several Supreme Court justices who have come down on the pro-gun side of a number of cases, including obviously the landmark Brewing case. But he also, instituted the bump stock ban. He has at points supported or praised the exact same policies that Bondi herself has. She, in fact, her most explicit statements on backing something like red flag laws came in a meeting with Donald Trump at the White House when he was president after Parkland. So it maybe should not come as a surprise that this did not garner her pick and then the lack of questioning during her confirmation hearing on these topics maybe shouldn't come as a surprise, because this is where Donald Trump has been as well. But at the same time, Trump has not suffered politically from these sort of things in the past, and he hasn't, even during the primary when he had Republicans running against him, they did not, even ones positioned to his right, like Ron DeSantis didn't make this an active issue. And anyone who was upset by this, most of them, if they voted in the election, likely came home to Trump in the end because of Harris being the opponent and having a far more objectionable record on guns for gun rights advocates. So at the same time, I think, maybe a lot of gun rights groups or gun rights activists are willing to make that trade-off. But what Bondi's hearing, I think, demonstrates is where exactly the gun rights movement is on the totem pole of the new GOP coalition, which is, pretty far down those rungs. Like they're not going to win out in situations where Trump and the Republican Party have other priorities at play. And certainly Bondi, beyond her positions on guns, has been extremely loyal to Donald Trump, which she obviously likes, as most politicians like people who are loyal to them. But and so and I think she will do a number of things that he wants that supersede whatever she might do on gun policy. That was my big takeaway from the hearing, at least. I don't know if you agree with me or not. That was I elaborate a lot more on this in the analysis piece for members over at the Reload, but that is sort of the gist of it. There's a lot more detail to this as to why I've come to that conclusion, but it's hard to look at what happened in that hearing and not feel that the gun rights movement is well down the priority list of this new administration, and that the Republican senators are not making a fuss over this either. Like they're following that lead, at least for now.
Yeah. Reload members that are listening to this should definitely go check out that piece to see that argument laid out. And you can also check out, we did several weeks back when she was first announced, basically a rundown of the sort of complicated history she has with guns to give people a better idea of why it's surprising that no Republicans, broached this subject during the confirmation hearing.
And as I mentioned, it's not like nobody noticed this.
Right.
There were several gun rights groups that were criticizing Bondi and wanted the Republican senators to ask her questions on this, and nobody listened to them.
Right. Which I think says quite a bit about their at least relative status during this current moment.
For now.
For now, at least. But moving on to some legal section of our discussion this week, we had sort of a cornucopia of legal decisions or lack thereof to talk about. First and foremost is the Supreme Court had its orders list on Monday, where, all eyes were sort of on the court because they just had that big conference last week where including, looking at several gun cases, including the most closely watched, which is the assault weapon ban case. And to the disappointment of gun rights advocates, I think they did not issue anything granting in that case. They kept it alive. They relisted it to a future conference. But in that same orders list, they also denied cert in several closely watched gun rights cases, including Maryland's handgun qualification license case, as well as the preliminary injunction standard for Delaware's assault weapon ban and large capacity magazine ban as well. So both punting
so more bad news.
Yeah, so mostly bad news across the board. Yeah. No new grants, and at the very least, pushing away several gun rights challenges and maybe keeping alive some other ones.
Yeah, no, to be fair, while this is bad news overall, again, for gun rights advocates, good news if you're a gun control advocate, obviously. But they did keep alive the most important cases, right? The ones that are at the top of the gun rights advocates list of things they want to see the Supreme Court take up, which is obviously most notably an assault weapons ban case, and specifically the Maryland assault weapons ban case. This week's news was bad, but it was bad on again, if you're a gun rights advocate, you're probably willing to take a trade-off of the court not taking up a pistol purchase permit case and instead taking up an assault weapons ban case and coming down in your favor. That I think most people would take that trade. So, it's not all bad news. It is what the final dispensation for the cases that were in that order. Bad news for gun rights advocates, but the good news is that they still may well take up an assault weapons ban case, and I guess we'll see next week. I was
going to say they relisted them for the conference that was this morning, as of the day that we're recording, which is Friday. Yeah. They have another orders release date on Tuesday because Monday's a holiday. So there's a good chance we'll have some better indication there. And I was a little curious in the interim because I know anecdotally, at least, it seems that a lot of times cases that the court does take up tend to get relisted. And so I wanted to see if there's any data on that. And there's not super recent data, but I guess SCOTUS blog did some research from 2017 to 2022. And I guess roughly 70% of the cases that the Supreme Court took up over that period were relisted at least once. So for gun rights advocates that think, they're just kicking the can down the road just to crush our hopes, that's not necessarily the case. It's a pretty common practice for them to relist cases that they eventually take up. So there's still a possibility.
Yes. Also, wild story out of the SCOTUS blog.
I was going to say they're in the news as well.
Great resource, but man, the guy who runs it, only accusations and indictment. So, innocent until proven guilty. But man, the story that the government is painted in that case is just wild. It's very much, it's a lot like the movie Rounders. If anyone's ever seen that, if you're old enough to have watched the Matt Damon poker movie. But yeah, high stakes poker allegedly leading to this guy committing all sorts of crimes, all while still running the best Supreme Court reporting resource out there. So, which they were up and doing live stream today. So I guess it's not going away, but man, wild story on that from the SCOTUS blog. Very unfortunate because hopefully, I don't know. Hopefully it continues on because SCOTUS blog has been a fantastic resource, but regardless of the personal life of the founder.
Yeah, absolutely. One other case that was related to the Supreme Court's actions on Monday that sort of less discussed was another one of its grant, vacate, and remands of a felon in possession ban case. This is something that we've covered a lot because they do it. They seem to do it every single time one of these pops up to the court, is kick it back down and say, hey, consider Rahimi and do it again, even though all these other ones that we've covered have come back unchanged. So that's one to keep an eye on.
Which was another story that we had this week, right?
I was going to say, it leads us into. I can't remember. I covered the previous rulings, but it fitting that one of these cases, once again, from the Third Circuit came back. This one dealing with Pennsylvania's sort of de facto ban on gun carry for 18 to 20-year-olds because of the way that their concealed carry permit eligibility works during times of emergency. They can't
get a concealed carry permit, and then during emergencies, nobody can open carry. So during emergencies, effectively, anyone 18 to 20 years old cannot legally carry a gun is basically what the situation is in this case, Lara. And, the Third Circuit had previously struck the law down as unconstitutional under Bruin. And then the court granted, vacated, and remanded that to reconsideration under Rahimi. And to, I think, no one's surprise, perhaps, they did not change their mind on remand. This Third Circuit said, hey, Rahimi doesn't really apply. It doesn't really change anything about our reasoning. We already were doing the test right. So we didn't really need Rahimi to tell us that. But as you mentioned, we've seen a bunch of cases come down like that, basically just saying, yeah, cool, Rahimi is nice, but we already did this right the first time, so it doesn't change anything.
Yeah, unanimously across the board, in fact, so far, all of its post-Rahimi GVRs have come back with the same outcome. Not a single one has reversed course on its outcome.
Although there is a new case, I guess, that you put in the newsletter, and then you're going to have an analysis piece about out of Texas, or out of the Fifth Circuit, and that deals with, it's not quite a reversal because the case was heavily impacted by Rahimi, but the panel that ruled didn't previously rule yet before Rahimi came down. But the outcome is different from what the lower court found, right? And it was heavily impacted by Rahimi, it sounds like.
Yeah. This one's a little more nuanced, obviously, than the GVR stuff, since it is the first time that this panel is issuing a ruling. But listeners might recall this was back shortly after Bruin was decided. It was the first district court ruling to invalidate the federal gun ban for those subject to a felony indictment. And this was a pretty sweeping ruling because it was the judge in that case ruled it facially unconstitutional. So across the board, it can't satisfy any scenario where this might work under Bruin. And this one, caused a lot of hubbub in the media because it was one of the first of these big sweeping criminal justice type rulings that we saw after Bruin. And so, over the last 2.5 years, that's stood until this week when the Fifth Circuit finally issued its ruling on the appeal and said, actually, no, that judge got it wrong. This is constitutional. It fits within our history and tradition. And as you mentioned, Rahimi was cited. It was a 20-page ruling, and Rahimi was cited, I think, 18 or 19 times in the opinion. And the majority opinion, in fact, talks about how, when the district court made that decision, it was shortly after Bruin. And she says, while Bruin is an important guidepost for our analysis, Rahimi has further informed what we were supposed to do in these Second Amendment cases. And then she goes on to talk about how, it's just the general principles that inform our regulatory tradition that we need to look to. And so essentially loosening a bit the analogical reasoning that they're permitted to do. And it brought them to a scenario where they said, during the founding, people accused of serious crimes or charged with crimes could be held in jail before their trial. And being held in jail necessarily involves being disarmed. Therefore, the modern indictment gun ban has an analog and it is constitutional.
Right. And to be fair, Rahimi strikes a lot closer to the details of this case than many of these other cases, right? Because Rahimi was about the domestic violence restraining order and whether that was constitutional. And domestic violence restraining order, as the court made pains to point out, and several concurrences as well, that's a pretty narrow holding, that it only applies to, somebody who's been deemed dangerous by a court, through a court process, and they're only being temporarily disarmed, in theory, at least, under that federal law. So, but so that that's probably why a lot of these other cases that they've GVR'd just aren't. A lot of these lower court judges don't see the connection between that holding and their previous decisions, at least not to the point where they're going to overturn them. And even though Rahimi does do a little bit more on the back end of like here showing their work of how they got to this conclusion that this was constitutional, but yeah, that is certainly closer. A felony indictment is closer to a domestic violence restraining order than like Pennsylvania's ban on gun carry in emergencies for 18 to 20-year-olds, right? It's just a very different situation. But it is interesting now, because we've talked a lot about how Rahimi is not having much impact. And so here's a case where it did.
Yeah, and it also, the reasoning sort of strikes to the heart of one of the critiques Justice Thomas raised in his dissent. He was obviously the lone dissenter in Rahimi and sort of took his colleagues to task for what he perceived as sort of a watering down of the Bruin framework. And one of his lines is essentially, well, what you've done here, given that imprisonment as a concept existed during the founding, and since imprisonment necessarily involves disarmament, all you need to find is any law that has some semblance of a justification that's similar to that, and you can justify any disarmament regime. And that's kind of what the Fifth Circuit did, or at least the panel in this case did. They said, well, we were allowed to lock up criminals back then, and if you can't have a gun in jail, so therefore this modern restriction works.
Right.
So it is interesting that there was sort of a vindication of that concern.
Yeah, at least to some degree, right? That is an interesting parallel, and that's where, like, I remember we talked about at the time. One of my takeaways, at least, was, the court, and especially the conservatives, in responding to Thomas's dissent, a lot of them were basically like, all right, look, we're not going to go that far with this. We're not going to let this get out of hand. And, I think Thomas's concerns are reasonable until the court starts taking up cases in the other direction. Because Rahimi is the first case they really did after that refines Bruin at all, and it refines it to tighten the standard, right? Because the lower court there had found that the domestic violence restraining order gun ban was unconstitutional under Bruin, and they're saying no, you're going too far with this. They had the whole straitjacket versus blank check analogy they use in Bruin, and right now we have one case from the court that says, here's an example of a straitjacket ruling. They have not yet taken up a case and overturned a lower court by giving an example of the blank check as far as, gun regulation goes. And so the longer they take to do that blank check case, I think the more legitimate some of Thomas's gripes become. Or at least, the more prescient some of his predictions and concerns are. So, the court, especially this court, the Roberts Court, doesn't take up a lot of cases on a yearly basis. They've been one of the slowest of any Supreme Court. They just don't take on a huge workload anymore. And so, when that will happen, I don't know. Range obviously was a pretty primed example, although they would have been agreeing with the lower court in that case. But, I'm sure there's an example they could find out there to do a blank check case. Like, here's where the lower courts were too loose in applying Bruin. And that's how this is going to have to work over time. With the standard they've chosen, a lot of it is going to come down to whether or not the court agrees that these analogies are closely related to the modern regulation or not. And so, but you're right. I mean, maybe this will be I doubt it, because this is a facial challenge. It's a to
that point. I doubt this one will be. Not only that, but also because the indictment gun ban is less pertinent, I think, to the court's idea of what's urgent than, say, like the felon ban. Also, the indictment ban isn't for life. It's just while you're under indictment. If you're cleared at trial, you get your gun rights back. That's another
similarity.
And it's also not a possession ban. Like, if you already own guns while you're under indictment, you're allowed to keep those guns. You just can't acquire any new guns. So it's less restrictive than some of these other rulings that might be more pressing.
It's a bit of an oddity in that sense, but that's a very good point.
Yeah. So I doubt it'll be this one, but
yeah, probably not. But that's the thing. It's like that's how that's how a lot of jurisprudence at the Supreme Court works. And this is something I always try to emphasize with the Supreme Court and the Second Amendment. It's like the First Amendment, we've got 200 plus years of jurisprudence around that, right? Where they're taking cases and on either side of the standard, they're trying to whittle down and get things to a coherent place. And it's still difficult even after all that time with all the precedent. But the Supreme Court, I mean, their first ruling on the Second Amendment, maybe Cruikshanks, you could count that one, but really the current jurisprudence started with Miller, which was 1934, right? So they haven't been working on it for very long. And in that time, the Miller to Heller, there was nothing really that happened of any significance on the Second Amendment. And so most of the jurisprudence has really been developed since 2008. So it's not even 20 years old at this point. And they've only done it in 5 cases, right? Heller, McDonald, you could include the stun gun ban case, Saitano, though there's not a lot to that one. It's only, a 2-page per curiam ruling. Then you get to Bruin and now Rahimi. Not a lot to go off of. And they're going to have to do a lot more to really focus in on what they're trying to reach with this blank check straitjacket standard that they've come up with for historical analogs. So, they have a long way to go, but we will keep on top of it for sure.
Absolutely. One of the last stories we want to talk about sort of in the body of our newsletter is a guest post actually from Radley Balco, who's a prominent criminal justice journalist who's actually appeared on our podcast before. And this story that we posted or published this week from him deals with exactly what he was talking about when he was on our podcast last. And that is sort of an interesting ruling about the permissibility of firearms forensics and whether or not that is as reliable as it's often portrayed by prosecutors and law enforcement, and some changes that were recently made to the judge that made that ruling. Yeah,
so we had him on. I think it was 2 years ago to discuss what was at the time a kind of a landmark ruling where it was disallowing some of this forensic firearm evidence in a gun case, in a criminal gun case, because the science surrounding this stuff, especially the pattern matching, the idea that is sort of this, I think most Americans are familiar with this from TV, right? From CSI. But the idea is that you can match a bullet to the gun that it was fired from, right? That's one of the core concepts here, based on the markings left on the bullet. The same thing for shell casings, a similar idea. Not just the model of gun, right? But the actual specific firearm itself. The concept with this pattern matching is that every individual firearm leaves individualized special markings on the bullets it fires, or the shell casings it ejects. And you can use techniques to show that to a scientifically useful standard. And the question that's been raised is basically, is that any of that even true? We talked about that with Radley at the time. There's been a lot of people from outside of the firearms forensics community, the people who do that specific work, especially within law enforcement agencies, that question the basic premise of this stuff. A lot of other researchers from different fields, especially fields related to, coming up with scientific testing for theories like this, have been highly critical of the practices in the field and whether or not these are even, there's, anything to this. And so there was a judge in Chicago that essentially agreed with the critics of firearms forensic, pattern matching techniques, and disallowed evidence in the case. And it's a relatively small victory because it only applied to one courtroom in one city, but it was the first time that a judge had really done that. There have been other judges that have questioned this stuff or put restrictions on what forensic analysts can say in court during testimony, but he was the first one to really question the whole concept. And so that the update now is that this judge got in serious personal trouble later on, unrelated to the case, and was forced to step down from the bench. And so this case actually ended up being turned over to a different judge. And that judge has ruled on, a motion to reconsider basically this previous ruling. And she came down in favor of the forensic analysts. So essentially undid that sort of landmark ruling. And that's what Radley's piece is about. We've republished it for our readers, but he published it first over at his independent publication. He runs also an independent publication like the Reload, called The Watch. And so I recommend people check that out. But, this is a very in-depth analysis piece that he did for us, or they allowed us to republish. And it's very thorough and, gets into certainly it has links to both the rulings and to a lot of other stuff. And it's quite long, but I thought it was very well written and makes a compelling argument, about, the situation and the case and what's going on with forensic firearms analysis and some of the critiques and questions around it, because it's one of these things where it's deeply ingrained in the criminal justice system that this is, useful in not just, to some degree, but to the degree where you can put people in jail for the rest of their lives over what these analysts find. And when that's the case, you should be extremely skeptical or at least closely watch what, the evidence is that this works. And because, if you think about it on the surface level, it does sound hard to believe, frankly, like that you can take a mass-produced bullet fired from a mass-produced firearm and specifically match that bullet to that exact firearm. That is a pretty bold claim to make. And, some of the standards and practices around this field of study also just don't seem that inspired. They don't inspire a lot of faith, frankly, like the way that a lot of these labs don't use any sort of, testing to verify that they are doing this stuff, that what they're doing is actually viable. And so, not to say that it couldn't be, right? I'm just think that Radley raises a lot of good points, and it's a good piece. I think people should read it, and of course, decide for yourself after the fact. But the main thing is that whatever you think of forensic firearms analysis and those techniques and how accurate they are, there's still the fact that we had a landmark ruling against them, and then that has now been overturned. And it's important to understand what's going on in this space, because it does play into a lot of gun-related convictions throughout the country.
Absolutely. Yeah. Listeners should check out that piece. And if they want, they can go back to that podcast and also see some of the arguments that Radley made during that discussion as well, talking about some of the questions that this sort of technique raises. Getting into some of our newsletter links that we want to hit on this week. One of them comes to us from the Courthouse News Service, talking about a recent decision from the Ninth Circuit Court of Appeals to not take a case en banc. This one deals with sort of a challenge that was consolidated between both Hawaii and California's so-called brew and response bills, their restrictions on concealed carry in sensitive places. And I think the aspect of this that will be of most interest to our listeners is that the lower court, at least for Hawaii's brew and response bill, actually upheld the vampire rule, or the default ban on gun carry in private property, publicly accessible private property, the only court to date to do so anywhere in the country. And so the fact that the Ninth Circuit, by not taking this case en banc, is going to allow that to stand, I think is pretty significant, because it essentially invalidates the right to carry over vast swaths of Hawaii. Yeah.
And it creates a circuit split, or it preserves a circuit split. And so that makes it potential at least on the issue of the so-called vampire rule, the idea that, you have to invite in, that's where the vampire thing comes from. I guess for the vampires, they can't enter your home unless you invite them in. This is the old vampire lore. And so the gun rights activists have taken to calling this the vampire rule. But basically, the rule is that it's off limits to carry on any publicly accessible private property unless they post a sign that says you can, or otherwise communicate to you that you can. So that flips the standard that's always been in place, essentially, since the founding. And so it's been one of the most expansive and controversial aspects of these broom response laws, and one of the least successful in court so far as well. You've seen a lot of other federal courts have struck down that provision, even if they've upheld other sections of these broom response laws. So, this creates potentially more incentive for the Supreme Court to act again. A lot of these things are going to be like, which ones are the Supreme Court going to take up? When are they going to do it? Bruin opens up a lot of new questions, and they're going to have to resolve a lot of them. And this is certainly one of them.
Yeah, we'll have to see what the plaintiffs do in this case, whether or not they want to, apply for cert or just fight it, back on the merits. But this one does strike me as a particularly compelling candidate because it really gets to the heart of what Bruin decided, which was, the meat and potatoes of that case was being able to carry a firearm in public. And if Hawaii says, well, you can't do that virtually anywhere. Because
under these laws, you're, in practice, you're even less, if you had, before it was, you couldn't get a permit, but if you had a permit, you could carry most places, like other states allow. Now it's, you can get a permit, but you can't really carry anywhere. And I don't know that that's what the Supreme Court had in mind. So it seemed particularly vulnerable if the court ever actually gets around to taking one of these up. Yeah, but we'll have to see. They've been reluctant to do that until they get to final dispensation for a lot of these kind of cases, right? Yeah, that's a good point. Sticking with Courthouse News Service, one of the other links we want to talk about has to do with an update on NRA head Vice President Wayne LaPierre, who is now appealing the monetary damages he was found liable for. Obviously, in the corruption case, he's now trying. I guess he's already paid them about $4 million. And that's what Rocky Marshall said on the interview podcast last week. Really, I was kind of surprised to hear that he just immediately forked over the money he was found liable for. So. Now he's appealing. That part's perhaps not too much of a surprise, right? You'd expect he isn't super happy about the way that case turned out for him, and so he's appealing. The NRA is also appealing. We'll see if that one actually goes forward, because that, I believe, was the last act of the Brewer firm, which then has since parted ways with the NRA. It was only on the First Amendment claims. They tried to claim essentially that the case should be dismissed because of Letitia James's public statements, attacking the NRA and saying she was going to go after them when she was running for Attorney General. That the court found weren't enough to undo the case, at the trial level. So now that's what's being appealed, as far as I understand it, in the NRA case. And it's not clear if they're, that already went up. As far as I understand, those claims already went up once through the appeals process. So I don't, I'm not an expert on New York civil law and exactly how the process works, but I'd be surprised if that, is successful in the second time around, but we'll see if the NRA moves forward with that too. But the Wayne LaPierre one is certainly, I would expect that to happen. There is a fight, of course, as Rocky mentioned on the show, over Wayne's legal fees, because while he was working for the NRA, I believe he was still having his legal fees covered by the organization, which probably amounted to quite a lot of money. So, there may be a legal fight over all of that too. As much as the NRA seems on the precipice of a kind of a new era there, some of this stuff is certainly going to linger. Yeah, absolutely. That to me is the big takeaway from this, is as much as they're ready to turn over a new leaf, some of this stuff is still hanging around, and there's still fights to be had. So we'll see how it goes. And it may explain why they were a bit sidelined in that Bondi hearing. They really didn't say anything one way or the other about Bondi this whole process, either backing her nor criticizing her, anything. No mention at all, as far as I've seen, and certainly not on their website. So, they're kind of still in this turmoil phase. They're maybe at the end of it, but they're, and some of it's going to continue on, even if they are mostly through it, you're still going to have this stuff.
Certainly. The last link we want to touch on was your appearance on Cam & Company with Cam Edwards over at Bearing Arms, talking about the national reciprocity bill that was introduced in Congress by Representative Hudson, and why it's a little bit of a unique version of the long desired gun rights goal. And you're actually going to have him on the Reload podcast pretty soon here, right?
Yes, we did the interview with him. That'll be the interview podcast this week with Rep. Hudson, where we go over, we talked about the bill last week on the show, on the news update, but, it makes one big change, which is that it forces every state to recognize permitless carry by those who are residents of permitless carry states, if that makes sense to people. Like, it doesn't make the United States a permitless carry, everywhere, for everyone, but it does require other states to recognize that residents of permitless carry states can carry anywhere without a permit, essentially. So it's an interesting change, and it's interesting tactically, and interesting in that it doesn't go all the way there. And so we talked about that with Cam a little bit, and got his view and a little back and forth on that. And then I asked Rep. Hudson about that aspect of law and a bunch of other stuff too. Like, Hudson has really been kind of the point man on Second Amendment issues in the House GOP caucus for quite a while. He's usually the one that spearheads the National Reciprocity Bill. Sometimes he'll be the one who introduces the Hearing Protection Act, which is deregulating suppressors and silencers, so on and so forth. He's been one of the most active members on this issue. So it's good to have him come on and answer some questions about that. And I think it'll be good. Hopefully people will get a lot out of that. But yeah, it was good to be on with Cam too. For those of you who don't know, Cam Edwards of Bearing Arms lost his wife just recently to cancer. And so, he's certainly having a difficult time, and it was good to have him back doing the show again and being able to talk with him a little bit. And, I've been praying for him, and I would ask that anyone listening could, share prayers for him too. There's also I believe a GoFundMe or a Give Send Go fundraiser for him to try and take care of some of those expenses associated with the funeral and everything. So, if you're able, please go ahead and donate to that. I think it was in my Twitter and other social medias as well. But just a prayer too, or a kind word for Cam, if you're able to reach out to him, I think would go a long way. But it was good to see him and talk with him again.
Absolutely.
And so, yeah, I think that's all we've got. The Hudson interview, that'll be out on Sunday for Reload members, of course, who always get access to the podcast, the interview podcast day early, and can come on the show, by the way, if you're a Reload member and you want to be on the show and do a member segment. We haven't done one in a little while. So just reply to your members newsletter. That is also a member exclusive that comes out every Sunday, and let us know you want to be on the show, and we'll love to interview you. Always good to get to know some of the people who are supporting our work. It's been, I think, for most media companies and gun media in particular, a pretty hard time the last year or so. And that's hit us as well. So I always like to be able to talk to the folks who are, allowing us to keep this place going and to do the work that we're doing, and to try and, bring you sober, serious, firearms reporting and analysis that holds everyone accountable, and gives everyone a fair shake. So, just reply to your member's email and let us know. If you're not yet a member, you can head over to the reload.com and check out our membership options today. One, you'll be funding the work that we do here. That is how we make all of our money at this point, as a publication. It's 100% owned by me. We don't have any corporate overlords or what have you. And And it's fully funded by our members. So that's, if you want to support that work, you can go do it that way. And you will, of course, get a benefit for doing that, which is exclusive access to hundreds of pieces of news and analysis you won't find anywhere else. And early access to the podcast with Rep. Hudson coming out on Sunday. That's all we've got for you guys this week. We will see you again real soon.